All rise. The Court of Appeals, First Appellate District of Ohio, with the Honorable Jimmy Fox presiding, is now in session. Please be seated.
Good morning and welcome to the First District Court of Appeals. We have 4 cases today to be argued. When I say your case, if the attorneys or the party arguing could please rise and say your name, what party you're representing, and your readiness to proceed. The first case we have is Althouse versus Neeson et al.
Good morning, Your Honor. Justin Whitaker for the appellee, James No. With me is Eric Larson for the appellee, Julie Neeson.
Thank you. Good morning, Your Honor. My name is Rob Boone for the appellees.
Thank you. Okay, the next case we have in re guardianship of Ariana Hyde.
Linda Smith representing the mother, Melissa Pang, the mother of Ariana Hyde.
Thank you.
Derek Graham, Counsel for Advocacy and Protective Services, Incorporated.
Okay, thank you. Next we have U.S. Bank versus Barclay Campbell.
Matt Richardson for the appellee, U.S. Bank, Your Honor.
Okay, thank you.
Ready to proceed.
Okay, thank you. And then last we have State versus Bryant.
Good morning, Your Honor. Sarah Nelson on behalf of the appellate, ready to proceed. Good morning, Your Honor. Julie Myers on behalf of the ASN, ready to proceed.
Thank you.
Good morning, Your Honor. John Hill on behalf of the appellee, State of Ohio.
Okay, thank you. Okay, so on the first case, since there are 2 appellants, I understand that you are splitting time, and you are splitting it evenly, and you want to reserve 7 minutes. Is that correct?
That's correct, Your Honor.
Okay, thank you. Whenever you're ready, you may come up. Oh, and I will be using the light system. When you see the yellow light, you have about a minute left.
Thank you.
Good morning, Your Honors. May it please the court. We're here today on the appellee's appeal of Judge Shanahan's order denying their motion for attorney's fees and sanctions pursuant to for frivolous conduct pursuant to section 2351 below. We've thoroughly briefed the issues, and we assume that Your Honors have all read it. We don't need to belabor the points made in our papers. I think it's important first for the court to recognize that the bench told us in December of last year what it expects to see when a litigant comes before the court. The court expects to see references to the record, arguments supported by authority, and at least a recognition of what the controlling law in the case is. In this case, New York Times versus Sullivan has always been the controlling authority in this case from the beginning. The appellees, Ms. Neeson, Mr. No, and the others who are not before the court today have always argued and always relied on New York Times versus Sullivan for the actual malice standard. Ultimately, Judge Shanahan granted our motion to dismiss below under Rule 12b-6 because Officer Oldhouse failed to state a claim for which relief could be granted because...
And I can't remember if it was your reply brief or the other one where you all acknowledged that there is some contemporary concern and questioning over that standard, the New York Times versus Sullivan. You've got several, at least a couple of Supreme Court justices who have suggested that maybe we need to do away with that. So it does seem like there is an argument to challenge or back away from that standard. How does that factor into your sanctions motion?
And certainly, Your Honor, there are principled arguments. I believe you're referring to probably Mr. Larson's brief, but Justice Thomas and his acolytes have expressed an interest or a willingness to perhaps roll back New York Times versus Sullivan, perhaps in cases involving police officers. And that does factor prominently into our argument because Section 2351 requires a good faith argument for the modification, extension, or outright revocation of existing law. If a litigant can come before the court and make an argument for that, that is not sanctionable, whether or not the litigant prevails, whether or not the litigant is just wrong if they can come before the court with a good faith argument to modify Sullivan or even revoke Sullivan, that is not sanctionable. Front and center in our argument below and before the court was that there was no such argument made below. The argument was always that, well, first of all, was to ignore Sullivan all the way up until today. That you will not find any argument analyzing Sullivan or the actual malice standard in any of Officer Oldhouse's pleadings or Mr. Thuman's pleadings or Mr. Goddeson's pleadings. You will find continued argument that actual malice means something other than what it means, which is actual malice means knowledge or reckless disregard of truth or falsity. To this day, they will argue that actual malice means ill will or spite. In light of that very formidable authority, Sullivan, one would need to come before the court with a good faith argument to modify Sullivan, perhaps by relying on some dissent of Justice Thomas or some other federal jurist. That didn't happen below. The first time the court heard about it below, the first time we heard about that suggestion was at the oral argument on our motion, when the appellees said, we've been arguing this whole time for modification of Sullivan.
Mr. Whitaker, if you wish to switch, your 4 minutes is up.
Okay, thank you. And that just ties into where we are. There's been no good faith argument for the extension or modification of existing law, which would be sanctionable in this case under 2351. I will yield some of my time to Mr. Larson.
Thank you. Your Honor, I do want to address the question that you asked because it did appear in my reply brief on behalf
Sorry,
of...
I got the reply briefs confused.
No, that's absolutely. I think what it comes down to in that is, if we reverse back to the sanctions argument itself, as an officer of the court, it is my obligation, my ethical demand and command to acknowledge what the law is to whatever tribunal I am in front of. In front of Judge Shanahan, and I believe I cited to it within my written arguments and quoted myself from the argument. But basically what it boiled down to is I said, but you know, there is an escape clause. They can say, we're trying to change the law, and we've been trying to change the law, but they haven't.
So from your perspective, do they have to argue that on the motion to dismiss, or can they raise that at the sanctions proceeding to get protection from that?
My position is they raised it far too late. Because if you go through what Justice Thomas is talking about, many of his prior dissents that I've cited, such as Counterman versus Colorado, Coral Ridge Ministries was the big First Amendment case recently with all of that. It's a substantive due process argument. It's like what occurred with the changes and the overall overturning of Roe. It's not a stand up at the sanctions argument and say, oh yeah, that's what we were trying to do. And that's functionally what happened. In this case, and if you'd like, I can just kind of go down a list. Every time Sullivan came up, the actual malice standard was misstated. They were told, this is the actual malice standard by the Supreme Court of Ohio. They were told by you all the first time we came up and lost in the TRO issue. They were told clearly in all of the arguments and everything that we've ever put forward. They were told by Judge Shanahan this is what actual malice is. And yet, even on the sanctions response, their very first sentence before Judge Shanahan misconstrued the law.
And that's where you're saying they were conflating the actual malice standard with something that says, we don't like you.
You're right, and they've been conflating it since the beginning, and I hesitate to be this blunt. They have either remained willfully ignorant or chosen to completely ignore the law as it exists from the beginning of this litigation in 2020.
What did Judge Shanahan find in denying sanctions? Does she disagree with that?
It was actually a very brief entry. She said that they made an argument that simply by filing this complaint, and this was the first time we heard anything like this, and it didn't come up until after I brought it up in argumented sanctions, that they hadn't done it. Judge Shanahan said, and if you give me just a moment, I will.
Because she had granted their TRO, right?
She had granted their TRO
So she seemed to think
sometime
they
before.
had something.
That was way at the beginning, and it loops back to the fact that at the end of the day here, they're back to arguing the TRO. They're not arguing the actual law of defamation.
Well, Judge Shanahan's entry that's attached to your brief is just a page long.
Yes.
She elaborated all on the transcript as to the basis for the denial.
And forgive me, I've got the transcript right here. Where'd it go?
And she just said that the other filings in this case were warranted under existing law and or supported by good faith arguments.
And that's
for
functionally what she said, Your Honor. If you review the transcript and go back to it, what happened was she left the bench, she looked up Williams, which was cited again and said that, and then came back and said that Williams didn't apply, which was then, as before, raised at the appellate court argument we made before, and you pointed out that Williams did not apply. She then said, though, that she is not going to sanction them for any effort to change the law, but she did not elaborate as to what they had done or indicate in any way, shape, or form that they had done anything. It is our position they made no effort whatsoever to change the law. They relied simply on their feelings about if you're going to criticize a police officer and it's just wrong to do that.
But she seemed to believe that they did in fact attempt to change the law. And you're saying that was an abuse of discretion?
I'm saying that was absolutely an abuse of discretion. And frankly, it doesn't need to be an abuse of discretion because you guys have to know a review on that issue. But I would say it was absolutely an abuse of her discretion because it's just not true. If they can point to anywhere in the record, anywhere, where they were making an effort to change the law of defamation and its seminal standard that we all learned in law school that you can Google right now, and that if they took the time to get on LexisNexis or anywhere else, they would have found it immediately and known the weakness in their case. Had they made any argument whatsoever, point to the record.
Mr. Larson.
I've looked for it. My red light is on.
You're well over your time.
Thank you, I'm sorry.
Mr. Thuman. Good morning.
May it please the court, counsel. There's two procedural issues and one substantive issue. I'll briefly address the two procedural issues. The first was the decision to allow us to respond out of time on this particular motion. The standard review.
Yeah, we understand
We'll
that.
move on from that one.
We can move on from that
Okay.
one. I think, like, if you could address, do you agree that the New York Times versus Sullivan standard with actual malice is the governing standard in this case?
It absolutely is.
Okay, so can you show us where in the record you argued either that was wrong, that it should be extended, modified, distinguished, whatever?
I can't, Your Honor.
Okay, where would that be?
Throughout the oral argument of this case, the argument.
Oral argument of what?
Of this motion.
On the sanctions?
Yes, sir.
Okay.
The argument that was made, and quite frankly, the argument also on the motion to dismiss. That's where it was initially brought forward, the motion to dismiss. The argument was made that the words actual malice, and so in the definition of actual malice does not necessarily have to be placed in the briefing and so forth. The conduct of the defendants in this case, the conduct in threatening to dox a police officer and his family, the conduct of.
But again, this is what I was getting to, Mr. Larson. There's a conflation between doing something for spite or ill will which is not the actual malice standard. In fact, there's cases that say that's not actual malice from the Ohio Supreme Court.
It's true, but that's the point that we were trying to do. We were trying to argue that it should be actual malice. It shouldn't just be the words. It should be conduct. It should be the conduct of these defendants and what they did to this police officer and what they did to his family that rose to the level of actual malice. And by not citing New York Times versus Sullivan, or not saying, putting the round balls in the round holes and so forth, the argument was that's not necessary. The conduct of these defendants, the conduct is what matters.
Was there ever an explicit, we think that the law should change, that this standard should no longer apply, and instead, this standard should apply?
Well, certainly that was the argument, that the standard of conduct of the defendants should apply. It shouldn't be, again, just this square block and square hole argument where you have to specifically cite New York Times versus Sullivan and state the standard. Their conduct was such that any reasonable person, certainly reasonable lawyers bringing an argument, could make an argument that their conduct met the standard of actual malice.
I don't think, you're not answering my question. My question is, did you explicitly, anywhere below, other than at the sanctions hearing, did you say, acknowledge that New York Times versus Sullivan is the standard, and then argue that that should be changed?
It was also in the motion to dismiss argument. Oral argument for motion to dismiss is when we initially put forward the argument of the conduct of the defendant should be the standard. It shouldn't just be what is stated in New York Times v. Sullivan. It's the conduct of these defendants. And what's important about that is whether or not, of course, the standard being is whether a reasonable lawyer, or at least one of the standards, whether a reasonable lawyer would bring the action. We have to go back to the time that this took place. Not now. The pendulum has swung back a bit now. But at the time, in 2020, when this all occurred and when this happened shortly after Breonna Taylor. This happened shortly after George Floyd. The tension between police officers.
Right, but and I get all that, but that has nothing to do with the legal standard under New York Times versus Sullivan. New York Times versus Sullivan governs today, yesterday, 4 years ago. So the background context doesn't change that.
It does, because when New York Times was decided, the internet didn't exist. There were not individuals hiding behind keyboards making false, hateful, vile statements against police officers. And the term internet troll didn't exist. New York Times versus Sullivan could not have imagined the speed that hateful, vile,
I mean, you look at the Second Amendment, muskets are now being equated to, assault rifles. That's what the Supreme Court is doing. So
it evolves, of course, Your Honor, it evolves, and that's our point. It evolves. New York Times versus Sullivan never could have anticipated what we're dealing with in this time. The speed that these hateful, false statements against police officers spread around the world.
I don't think that anybody is disputing that that is an argument that could have been made. I think where we're getting hung up is, was that an argument that actually was made in this case?
The argument was made was, again, we were attempting to expand New York Times v. Sullivan to the conduct of the defendants.
And we can find that you're telling us in the
oral argument on the motion to dismiss and also on the motion for sanctions.
The oral argument,
Correct.
So it was not included in the briefing.
We hung in there with, we tried to argue that Williams applied. It was not agreed that Williams was the controlling case. We tried to make the argument that was the controlling case, and we lost. But we made an effort, and in that case, that would run contrary to New York Times. So, but yeah, we pushed forward with the Williams
let me ask you this, because I think one of the things that struck me in the prior appeal was you all were appealing Judge Shanahan's decision, and she provided a fair amount of reasoning as to why she was ruling against you on the motion to dismiss. And I didn't understand why you all were not addressing the substance of her decision in your briefs. You didn't say she got it wrong. You didn't say, she misunderstood something. It was like ships passing in the night. How do you not address what she decided when you're appealing it?
Well, again, she decided based on the New York Times standard. That was her decision. And we were again trying to expand that. So, we continue to push the, to push the Williams decision. But, importantly with that, Your Honor, you bring up the appeal on the motion to dismiss. Importantly, this court in its December 27th entry said that we had reasonable grounds for appeal. I mean, even though we lost, we had reasonable grounds, which should certainly mean that a reasonable lawyer brought a case, was proper in bringing the case. So, I think the other argument that is critical here is we were a prevailing party. Your Honor, you brought that up. We were a prevailing party in at least some of this case. We won on the TRO.
Yeah. Wasn't that confined to whether one of the parties could publish the personal information? So it didn't have anything to do with whether there had been defamatory statements, which I believe that is what the motion for sanctions was limited to, the defamation claim.
So our motion in equity was not only to prevent the doxing. They were arguing. The first thing they did is they started with these false statements against Officer Oldhouse, and then it expanded to doxing him, the threat of doxing him. So when we filed our motion for a temporary restraining order, not only did we attempt to stop the defamatory conduct, what we allege to be defamatory conduct, but also just to prevent the dissemination of the officer's personal information, of course, for the safety of his family and so forth. And that was granted. So, Your Honor, you're correct. It was granted in limited scope, but still, it was granted in some fashion. I mean, part of the claim that we brought, we were successful. And in fact, one thing that's interesting about that too is, they appealed a temporary restraining order, which by its name in itself is not a final appeal order. It came before this court and was quickly dismissed. It went to the Supreme Court and was quickly dismissed. And now it's sort of ironic that they're seeking fees against us for all the appellate practice that took place that, that they're doing. But anyway, the point is, we were at least a prevailing party for part of this case. I mean, cases happen all the time.
I don't understand that argument, because you won on a TRO, which has a totally different standard than on the merits.
Much higher standard.
And then the case got dismissed on the 12b-6. So, I just don't understand how you can say that you're a prevailing party.
Sure. Yeah, we bring cases all the time where we make certain allegations and certain claims and certain counts where courts routinely, at the initial pleading stage, dismiss part of the claims. That doesn't make the entire complaint. I mean, we can plead in the alternative. We do that all the time. Contract claims, we plead unjust enrichment and so forth, which you can't have both of them. I mean, it's something that's permissive. So just because some of our claims were not successful, certainly some of them were. So we were reasonable, we were justified in what we were doing in bringing this claim. So, unless there's any more questions, Your Honor, at this time we're just requesting that the court affirm the underlying decision on the two procedural issues, and also on the court's decision where Judge Shanahan found that we had a good faith argument for the extension of existing law, and we believe that we do, and we did. Thank you.
Thank you. Okay, since you went over, both of you went over a bit on the opening, you have 5 minutes for rebuttal.
So, okay,
Yes.
excellent. I'm going to try and take 3 minutes only, because Mr. Whitaker wants to speak on doxing. I'll go as fast as I can. First off, at this point in time, I don't believe that we have a response on anyone in terms of these motions, in as much as the attorneys are respondents here for their behavior and their conduct. I don't believe at this time that we have any response as to them, the attorneys themselves, only as to Officer Oldhouse. I'd like to jump right in, since he points to his words in the oral arguments.
Before you go on, I just want to clarify one thing. Your motion for sanctions was limited to the defamation claim, correct?
Functionally, yes, because that was where the law of the defamation claim comes. They were granted a TRO. We disagree with it, but they were granted that.
Okay.
We fought prior restraint there. I did not bring with me the motion to dismiss oral arguments transcript. I'm sorry, I don't have that with me. That said, I cannot pull a single point in my mind out of it where they argued to change the fundamental law of defamation in this country, where they work towards substantive due process, as was done with Roe, as is what Justice Thomas is considering in a number of dissents where he speaks about substantive due process and free speech and the standards. Here's what they say, and I quote, this is Mr. Thuman: "We don't have to, in our initial case, make an argument that we're trying to change the law. Just by what we were doing was a good faith effort to make a modification of the law. The primary argument that I made was on this issue is when you call a police officer a racist, that is the worst thing that a person could be called in this day and age. Calling somebody a murderer is not as bad as calling somebody a police officer a racist." We're hearing recycled arguments since day one, the same thing, abjectly and completely ignoring the standard, and perhaps most offensively to me, ignoring our First Amendment rights outright. He then goes on to say, and by making that argument, that is actual malice. It's not. It's absolutely not. It's not the law, it's not an effort to change the law, it's an effort to misconstrue, misunderstand, and ignore the law on behalf of a police officer such that individual citizens would be chilled from talking about their public officials and the people who are supposed to defend them. I'm going to leave it at that. I know you guys have everything. I'm going to give Mr. Whitaker his time to talk about doxing because he wants to address that today. Thank you.
Thank you, Your Honors. Very briefly, I just want to reemphasize that our motion for sanctions was brought against Officer Oldhouse and his attorneys. And we are here today on appeal, and only one response has been filed, and that's been on behalf of Officer Oldhouse. You've not heard from his attorneys. As to the question of doxing, there's been this repeated effort to suggest that the conduct of the defendants below was something that should be considered doxing, or an effort to harm by their actions. The Supreme Court in the Shanahan case said absolutely not. The Supreme Court in the Shanahan case said there's nothing anywhere close to a true threat here. What Mr. No did was inquire about what he could do, what his rights were, about what he could publish. Excuse me, the Supreme Court said that's not doxing. Even if it is doxing, doxing is not tortious conduct. In any event, it's all part of a larger effort to falsely portray conduct and to shoehorn that conduct into what they describe as actual malice. To be shown by conduct that's false and also does not meet the New York Times standard. And unless Your Honors have any other questions, I think we've said all we need today.
Okay. Thank you. Your case has now been submitted, and we will issue a timely decision.
Thank you.
Have a nice day. Okay. And if I could have the parties for the in re guardianship of Ariana Hyde, please. Ms. Smith, would you like to reserve any time?
A couple minutes.
Okay. Whenever you're ready, come on up and get started.
Thank you for being here and for this opportunity to argue this case. This case is very important to me because of the constitutional basis behind this case, which is the First and 14th Amendments to the Constitution of the United States, which deals with protection of the relationship between the parent and child. We're here because my client filed an application for guardianship of her child. That application was denied. In a nutshell, the decision was that the stranger guardian should not be removed for cause. Therefore, it's in the best interest of the child to have a stranger guardian. In a case of this nature, when a parent, mother or father, files an application for guardianship, the issue is why shouldn't the parent be the guardian? Because of the constitutional safeguards. The courts have looked at this issue and determined that it's a best interest standard that's used. That's how we measure it. Instead, the decisions was answered the question, why shouldn't the stranger guardian be the guardian of the child? That was what the decision answered.
Well, like, you're not challenging the threshold decision on the guardianship. I thought this was simply to try to remove the guardian. Is that right?
No, sir. Okay. And that is very confusing. When you file in probate court an application, because I did this, for the mother to be guardian of the child, and there is a guardian already appointed, they demand or require you to file a removal application. And therein lies the rub. And so the hearing was all about the stranger guardian being removed as opposed to the best interest of the child. And ORC 2109.24 was used, the for cause standard was used, when in fact we're looking at an application for the mother to be guardian.
So are you saying the wrong legal standard was used?
Correct.
What's the appropriate legal standard?
2111 deals with guardianships of the person. 2109.24 deals with fiduciary, money. It does not deal with the person. Now, the courts have allowed probate courts to use 2109.24 catch-all provision at the end that states that for any other cause consistent with the law, whenever looking at an application.
And I'm sorry, Ms. Smith, but is this in your brief? I'm looking at your brief right now, and I'm not seeing.
On page 10, I talk about the best interests.
Okay.
And of my. Oh, you're talking about the brief. I'm looking at the objection.
I'm talking about, like, you're saying that the wrong legal standard was applied. That's what you're telling us today.
Mm-hmm. Correct.
And I'm looking at your brief and trying to figure out where is that in your appellate brief?
It is in my brief when I say that the wrong, because I say in the very beginning that we have to use de novo because of the wrong legal standard was applied.
So the correct legal standard is what? Best interest?
It's best interest.
Because I'm looking at the court's order that's attached to your brief, and the court says that it cannot find that it is the ward's best interest to remove the guardian. Ms. Payne has asked that a good cause standard be applied.
That is not correct. I did not ask for that. And I did see that.
Okay, so that's where I'm getting confused, because
it
looks like the court did apply a best interest standard.
No, what the court did was, read the very short decision. What the court did was, they said, the stranger guardian can't be removed for cause, therefore it's in the best interest that the stranger guardian remain guardian. They never answered the question of why mother should not be guardian. Had they done so, the record would have supported her being the guardian. They never answered the question of why she shouldn't be guardian. The application was there.
Can you tell us why the record supports mother being the guardian then?
First of all, mother provides all the companionship for this child. She takes the child. She's the only one that takes the child out of the facility and spends 10, 12 hours with the child, on a weekly basis. This was all in the testimony. She provides all the clothing, all the entertainment, all the hygiene for the child, because she is a black child that requires some different hygiene. She was in a all Caucasian facility out in Batavia. And she provides all the companionship. But more important, just as importantly, she has a constitutional right. Unless there is a government interest, a prevailing government interest, which the courts have determined to be in the best interest standard. If there's a prevailing government interest, that equals best interest standard. We have to say mother cannot be the guardian because this X.
Because
X,
it's not in the
X,
best interest.
Because of X, and X is not in the best interest of the child. You have to answer why. The Constitution requires us to answer that question, because a parental mother-child, father-child, parental relationship with a child is protected by the First and 14th Amendment. You have to show a prevailing government interest.
And the reasoning that you're pointing to is included in the magistrate decision, right?
Correct.
Not the judge's ultimate.
Right. The judge.
The judge kind of just came to a conclusory decision that it was in her best interest.
Right.
Okay.
So you have to go back to the magistrate's decision in order to understand the.
Do we go back to the magistrate decision, or do we just look at the record to determine whether the judge, I guess this is an abuse of discretion, correct?
No.
Is it de novo?
This is de novo.
Okay.
They used the wrong law.
So I'm sorry, like, this is what I'm trying to figure out, and I think we've all asked this in various ways, but like, you're saying they used the wrong law.
Mm-hmm.
I'm trying to understand what laws you say applies, because I see the trial court using the best interest standard, and I thought that's what you were saying is the standard. So I just want to make sure I'm not misunderstanding something.
The law that you can't say, I mean, they did say, so I guess you could say, so it's against the law to say that mother cannot have guardianship of her child because the stranger guardian cannot be removed for cause. And since the stranger guardian cannot be removed for cause, it is in the child's best interest to have a stranger guardian. 2109.24, which is removing a guardian for cause, that applies to someone, guardianship over the property, not the person. 2111 is guardianship over the person, and it uses the best interest standard. 2109.24 does not use the best interest standard. It doesn't even have anything to do with guardianship over the person. But that is what was used. And then I cite the cases. They're very good cases, Raybeck and Spangler. Raybeck does an excellent job of explaining what I just told you. So, you know, I encourage you to look at that. However, if an abuse of discretion, I'm arguing it should be reviewed de novo because they used the wrong law. You can look at what the court is referring to, 2109.24, and you'll see that that's the wrong law. I know that.
But if the court applied the correct law, it would be an abuse of discretion standard?
If the court applied the correct law, the court would review the transcript. Is that correct?
I'm just asking you if we determine that the court, you're arguing the court applied the incorrect law. If we determine the court applied the correct law, would we be reviewing the court's decision for abuse of discretion? If that's
You would be.
Okay.
And if you do, then I would submit to you that with abuse of discretion, suggest that the decision was unreasonable, arbitrary, or unconscionable. And I would suggest to you that the decision was unreasonable, because there's nothing in the record that suggests mothers should not be guardianship. In fact, all the witnesses we called, which really wanted SODC to keep, or APSI to keep guardianship, they wanted APSI to keep guardianship, but they supported everything about mom, and in fact, all of it, she is a good advocate for her child. Yes, she does take her child out without incident. Yes, she does do this. Yes, she does do that. There's nothing everything in her record suggests that mom should be guardian of her child. There's nothing there. We must answer the question, why shouldn't mother be guardianship of her child? Otherwise, anybody can walk up to you and say, I want to take your child. And we don't have to answer the question, why you shouldn't be the parent of your child. Why we shouldn't interfere with the relationship with your child. Anybody would be able to say that. They have the Constitution, the law, the way that the First and 14th Amendments is, you have to come up with a reason why, a prevailing government interest.
Ms. Smith, if you want to reserve 2 minutes, your time
Okay,
is up.
thank you. I appreciate it.
Mr. Graham, whenever you're ready.
Thank you. May it please the court and counsel. Advocacy and Protective Services Incorporated is an entity that just strives to do exactly what the probate court is also supposed to do, which is pursue the best interest of the individual. I don't disagree that at the heart of every guardianship matter is what's in the best interest of the individual. That's exactly what APSI wants. That's exactly what the court was pursuing in this case. I think there's some confusion here because at the time APSI was appointed guardian, the court heard multiple applications. They heard applications from APSI. They also heard an application from mother at that time. And the court decided then, with 2 equal applications in front of it, that APSI...
And remind me when that was?
That was at the outset...
2019, sorry?
I believe so, Your Honor.
Okay.
At that point in time, the court determined APSI was an appropriate and suitable guardian for Ms. Hyde. Now, a lot of what my opposing counsel was referencing talks about the relationship between a mother and a daughter. And APSI has no interest in impacting or diminishing this mother's relationship with her daughter whatsoever. APSI's interest is in coming in as a neutral third party and making decisions, larger global decisions, for somebody that is very difficult to serve. Ms. Hyde is a wonderful young lady, but between her developmental disability and some of her mental health conditions, it is very difficult to serve her, which is why she was at the Southwest Ohio Developmental Center to begin with. APSI takes that very seriously. APSI certainly wants the family's input and certainly wants the family to be involved in those decisions.
And then there was something, and maybe this is beyond the record, but there was some indication that she's been transferred to a less restrictive environment?
Yes, Your Honor.
Is that right? Okay. And when did that happen?
I do not know the exact date, Your Honor.
But that's not in the record?
Yeah, no, it's not. Okay. That happened subsequently. So, Mrs. Hyde, and again, certainly APSI, as guardian, if the court finds a family member is suitable, there's nothing in Ohio law that provides a preference of family over a neutral third party. But at the same time, APSI's policy as an organization is we always want to serve as last resort. If there's anyone else that the court finds suitable or appropriate to be guardian, we will happily resign and let that family or that other person serve. There's cases like N. Ray Smith out of the 12th District that say sometimes a neutral guardian is appropriate just to protect the overall decisions being made. In a situation like Ms. Hyde's, I think that the driving force for why APSI is involved is the residential placement. Ms. Hyde is difficult to serve in the community. There are a lot of moving parts that have to be lined up between providers, residences, And there's a lot of benefit to having the expertise of someone like ABSI be her guardian. That was all in the transcript of the removal hearing. Also, the matter that was being appealed today was ABSI's removal. And I agree with my opposing counsel that if you read In Re Guardianship of Rayback out of the 3rd District, it's a very good case. And I agree with the holding in that case wholeheartedly that says a court can remove a guardian for those grounds enumerated under Ohio Revised Code 2109.24, but also anytime they think it's in the best interest of the individual. I think if the court did find, hey, we think it's best that mom be guardian and not ABSI, I agree that the probate court would have the authority to remove ABSI on that finding alone. In this case, the magistrate's decision not only found it was in the best interest for ABSI to remain guardian, but also indicated in his decision that all individuals testifying said ABSI was doing a good job. And one thing ABSI always strives to impress upon family members is when ABSI is involved as a guardian, we don't view that as a forever appointment. If there comes a time where we think it's appropriate to hand that off to a family, we'll go with family to the court and say, hey, let's let family do this. So I'm happy to answer any questions the court has.
Did the magistrate, I mean, I question whether we can look at the magistrate decision, but did the magistrate decision explain why it was not in the best interest of the child for mother to be guardian? I mean, certainly the organization's doing a good job, but was there any discussion about why mother shouldn't be guardian?
Not specifically in that decision.
Okay.
And not specifically in the written magistrate's decision.
Should there have been?
I don't believe so. I think the best interest is an overarching authority that a probate court has in every guardianship of an adult case. I think between the In Re Santrusik, In Re Spangler, these Ohio Supreme Court decisions, they make it clear that a probate court always has the authority to do what's in the best interest of an individual. I don't think that in a motion hearing to determine whether ABSI should be removed, that a court should have to make a specific exclusion of every other possible guardian.
I think part of the issue here, it seems to me, is the probate court's decision doesn't explain its reasoning. It says it's not in the best interest to remove the guardian, but it doesn't explain why, and I feel like that's part of what Ms. Smith is getting at, is not understanding the why question makes it difficult for her client to understand why the probate court's doing what it did.
To that, I would respond that at the underlying hearing, and in the transcript of the underlying hearing, Your Honor, they called several witnesses, all of whom said ABSI's doing a great job, and all of whom said placement in the community is going to be very challenging for Ms. Hyde. Mm-hmm. And the appellant in this case, during her testimony, said she would want to bring the daughter home to her and have her live in her home. And that's a very noble goal. I would never have anything negative to say about a mother that wants to bring her child home to live with her. But for an individual like Ms. Hyde, that is an underlying concern for courts.
But was the testimony that the mother wouldn't be able to handle taking care of her daughter, or her home wasn't equipped to take care of the daughter? I mean, was there anything like that?
In the removal hearing testimony, it was touched upon, but not in great depth. If you go further back in the record, at the time ABSI was appointed guardian, that was addressed at that time. There was a concern of the court and that she needed, and also keep in mind, she was in SODC on an involuntary placement.
So at the time that the initial guardianship was appointed, the court actually looked at and explained, okay, mom's not equipped to take care of her daughter, so, right? I mean, there was an explanation.
That's my recollection, Your Honor. I don't want to misquote the court's underlying decision.
But in this case, it was simply, ABSI's doing a good job, we're just going to keep the status quo.
Yes.
Okay. All right.
If there are no other questions, I thank the court for its time, and we rest on our motion.
Thank you. Ms. Smith, you have about 2 minutes.
Thank you. We talked about what occurred 5 years ago when mother did not get guardianship. It was explained at that time by the court that they didn't give mother guardianship of the child because she didn't have an appreciation 5 years ago of the child's mental illness. Therefore, it was in the best interest to appoint a stranger guardian. Here, that is not the case. There has been no everything in the record states the mother can be the guardian of her child. She does everything anyway. I mean, look at Raybeck. Raybeck was the same case. Underlying that case, the court had given the niece or daughter guardianship of her father because she did provide all of the society and this and that, companionship, entertainment, whatever. But they did not give the daughter guardianship over the money, and that's where the appeal came in. And so, that's why they went over 2109.24, which you have to, if you use, the appellate courts have allowed the probate court to get away with using 2109.24 catch-all provision. But the catch-all provision wasn't even used in this case. The only thing that was used in this case was the 2109, the four cause. Absy so great, absy this and that. And we all know that people, if you have to check off the box that you're going to see my child 5 times a year and that's all you have to do, I don't know what you call good service, but I'm sure they do the best they can, and that is a last resort. I agree with that, a last resort.
Ms. Smith, you have a few seconds to wrap up, please.
Okay. A stranger guardian necessarily interferes with the mother and child relationship. And mother hasn't said that she's seeking to change where the child is currently at. She did change where the child was, but the child is currently in a good place and the mother would probably most likely keep her there.
Well, so is this dispute moot then?
No, it's not moot because mother is still doing everything for the child, but yet the stranger guardian dictates how she moves, when she moves. It's still interference. Anytime you have a stranger guardian, it's interference in the parent-child relationship. Thank you.
Thank you. We are going to take a brief recess so that Judge Kinsley can replace me for the next case or the next couple of cases. And your case has been submitted and we will issue a timely decision. Thank you so much.
All rise. The Court of Appeals, First Appellate District of Ohio is now in recess.
Mrs. Campbell, has Mr. Campbell arrived? Okay, Mr. Richardson, would you like to argue or would you like to submit? It's up to you. Okay, thank you very much. We appreciate it. And the final case for the day is State versus Bryant. Good morning, Ms. Nelson. How much time would you like for rebuttal?
3 minutes for rebuttal, please. Good morning, Your Honors, and may it please the Court, and good morning, opposing counsel. Sarah Nelson, again, on behalf of the appellant, Ms. Jordan Bryant. In this case, Ms. Bryant appeared before the Hamilton County Municipal Court on applications to seal her criminal record, and 7 eligible convictions are now before this court because they were denied on the basis that the court found Ms. Bryant was not sufficiently rehabilitated and the government's interest in maintaining the record outweighed Ms. Bryant's interest in having them sealed. Notably, these are the same 2 factors under the expungement law that was considered by this court in State v. GH, a recent decision from 2023. And because, in our view, State v. GH is directly on point to the issues in this case, we are asking this court to reverse on that authority in order Ms. Bryant's applications be granted. So I'm going to address the rehabilitation and interest balancing factors separately. So turning to the rehabilitation factor, the trial court in this case directly stated that Ms. Bryant was not sufficiently rehabilitated based on the numerous convictions on her record. Why that's problematic, as this court pointed out in GH, is that the number of convictions is not a proper consideration because it's inconsistent with the legislative intent.
What should the trial court have looked at in considering rehabilitation?
I think timing of the convictions is a relevant consideration. So Ms. Bryant applied in 2023, and the most recent conviction on her record was from 2019. If she had a conviction in 2023, a different.
Do we know anything about the 2018, 2019 convictions? Like, do we know like what happened there? Like, we saw, I think it was probation report or something that indicated those, but didn't give any details. Do we know anything about them in the record?
No, Your Honor.
Okay.
Yes, they are in the probation report. It's my understanding per the court's entry was that they're out of county convictions.
Okay.
So my understanding of probation reports is that you get the entire history.
Right.
Any state, any county in Ohio would be produced in that report. And just if the court will indulge me on a little legislative history and punishment law, the number of convictions used to be relevant. If you had a conviction from a different county, there used to be a time where you could only have 2 total misdemeanors sealed on your record. So if you had 2 in Hamilton County, but 1 out in Cuyahoga, that would be relevant, but it's no longer relevant. You can have an unlimited number of misdemeanors in theory because there's no longer a barrier to the number of convictions.
Well, doesn't that go to eligibility as opposed to rehabilitation?
Not anymore. So number of convictions used to be an eligibility determination and it's not anymore. So that's why I think in GH, this court recognized that number of convictions isn't a proper consideration when it comes to rehabilitation.
Sorry, I wasn't completely, there's no limit on number now?
On misdemeanor convictions.
On misdemeanors, there's unlimited.
Correct. The only barrier is the type of conviction.
So I guess the way I was looking at it is, you have somebody that had conviction after conviction after conviction, and then they stopped their life of crime.
Yes.
And I guess in my mind, I'm looking at, okay, so then we start looking at rehabilitation after they stop their crime life.
Mm-hmm.
How many years have gone by, and like what have they done?
Correct.
Right?
Mm-hmm.
So rather than looking at the number of convictions.
Correct, yes.
Right.
So that's why the trial court's decision in this case was problematic because its rehabilitation finding cited the numerous convictions on her record. So problem because it's referring back to life of crime before the last
Before they cleaned up.
Yes.
Before they got their life together.
And to that point about getting your life together and cleaning things up, Ms. Bryant in this case actually advised the court that she was granted her certification of qualification of employment. That is significant because in order to grant that, the common pleas court that she appears in front of has to make a rehabilitation determination. And in the transcript of the docket, in every single case that was before the trial court and now on appeal in this court.
Aren't there 2 paths to get a CQE? Like one is based on rehabilitation and the other is not?
So my understanding of the CQE process is that you apply to the court and basically it's a rebuttable presumption on rehabilitation.
Well, but it depends like what posture you're in, right? Like how long it's been since the conviction. Like there's a couple of criteria.
Okay.
I'm going from memory here.
Yeah,
so.
Likewise. So my understanding, and as I pointed out the specific subsection in my brief that speaks to rehabilitation, and my understanding is that that is a threshold finding in order to grant it.
Okay.
The trial court can deny it if they find the person insufficiently rehabilitated, but that's not what occurred in this case. Ms. Bryant told the court that she was granted a CQE, and interestingly, the trial court doesn't even mention that in its findings.
So are you saying that anytime a court grants a CQE, that a different judge is just going to have to say, okay, rehabilitation has been met here?
Not necessarily. So after the CQE was granted, hypothetically, if an applicant now comes before a trial court and they have other criminal convictions on their record, that's a different situation.
If things change, but if everything stayed the same, then you would say that this judge would be bound by the CQE determination?
Bound, not necessarily, but it's support. My point is that Ms. Bryant offered support for rehabilitation in this case. She told the trial court judge that she was granted a CQE.
But the trial court judge could still, despite the fact that a CQE was granted, could disagree with the other judge and say, well, I know the other judge might have found rehabilitation, but I don't find rehabilitation.
Interesting. Perhaps, and I would probably take issue with that specific finding if that had occurred in this case. But I think what is more problematic is that the court seemingly ignored that representation because it didn't mention it in its rehabilitation discussion in the entry. It just cited the numerous convictions on her record, which for 2019 previously, and no criminal activity since then.
Would there be any res judicata or preclusive effect because the CQE proceeding is between Ms. Bryant and the state, And based on your representation, there's been a finding that rehabilitation has been satisfied. So if the trial court's looking at an identical set of facts, why would it be able to reach a different legal conclusion?
I don't think it should be able to reach a different legal conclusion, and I think there should be weight given to the common pleas court finding as to rehabilitation. But I respect that, this came before the trial court from a pro se litigant and is just offering, whatever she has to explain that she's been rehabilitated.
Well, and I think that's part of the issue here is and I don't fault her for this because she's doing the best she can to navigate the court system and she's presenting what she thinks is appropriate in response to the judge's questions, but she's not building the record the way that you or your opposing counsel would build a record. So how do we evaluate that in light of the judge's decision?
Well, I don't think that that's problematic, mostly because my recollection of the facts in the State v. GH case, the applicant didn't speak to the court. There was no offering of rehabilitation personally to that court. So if this court was willing to reverse on the number of convictions, the nature of the convictions, which is the same analysis that we see here, Ms. Bryant offered more than that. She told the court, I was granted a CQE in 2021, and she told the court that her criminal record has precluded her from getting a job before, and now she's trying to pursue a career in social work. So it does matter to her more than ever to get this cleaned up. On that point, I would turn to the interest balancing factor, where the court relied on the fact that, in its view, the public has a right to know of the criminal convictions on her record, which in this case, in which GH, this court explained the nature of the conviction. Backing up. The trial court said that the public had a right to know that she was convicted of several crimes of dishonesty, which invokes the nature of the conviction sort of analysis that this court pointed out in GH. The nature of the conviction isn't an appropriate consideration, and it was deemed to be an abuse of discretion by this court because, again, the legislature has told us which types of offenses are eligible to be sealed. There's no dispute in this case that all of the cases that were before the court are eligible. They met all the timing requirements. There was no objection by the state as to the specific offenses. There was also no offering by the state in terms of an interest to maintain the record, which I think is significant because the court imputed its own governmental interest in this case, the public's right to know, which this court debunked as an insufficient basis. It's an abuse of discretion. The nature of the conviction is irrelevant.
Counsel, can we go to the other side of the weighing, which is Ms. Bryant's interest, because there's some government interest that gets weighed against her interest. And my understanding is that the CQE proceeding also involves looking at whether Ms. Bryant has a substantial need for getting that certificate. Did the trial court consider her substantial need? Was there a substantial adjective attached to her side of the weighing?
I think that if I recall the entry correctly, the court acknowledged the interest in having the record sealed for purposes of employment. I don't remember, I can double check the entry, the substantial language. But the statute says governmental interest, if any. So that implies that the government might not have an interest. And in this case, they didn't articulate one. I'm not familiar with the CQE requirement about the governmental interest substantial balancing. I'm more familiar with the rehabilitation aspect of that statute. But if that is a factor for the CQE, then that's even more support in this case, that Ms. Bryant has shown a substantial need in clearing up her criminal history to prove to employers that she is somebody who is in fact trustworthy and employable. She has been sufficiently rehabilitated by recognition of our common pleas court. And then in this case, she told the trial court that she's been, her applications for employment have been frustrated due to her criminal history. And having had that experience and in pursuit of a social work career, it's more important for her now than ever to have her record cleaned up.
Is it possible that the trial court undervalued her interest in conducting the weighing that's required?
Yeah, I would say that's possible, yes. Undervalued, and not only that, but weighed an interest that wasn't articulated by the state. So
that's my question. Does the state, if the state doesn't articulate an interest, then there's no interest of the state? Is that what you're arguing?
I think that's what I'm arguing.
Okay.
I think the statute supports that.
Okay.
It doesn't say any conceivable interest. It says a governmental interest, if any. And I don't think it's appropriate for the judiciary to impute an interest.
Okay, so if the state doesn't articulate an interest, then the judge shouldn't come up with an interest. What you're saying, what he came up with was improper under the law, but
Yes, yeah, a couple of things.
even if the judge came up with something proper, you would say that that was error because the state didn't articulate the interest.
Yes.
Okay.
Yeah. The state should say something if they have an objection. They didn't in this case. I see that I'm out of time, but I agree with your
Okay.
summary of my argument.
Great,
Thank
thank you. Ms. Myers, good morning.
Good morning, Your Honors.
I understand you're going to take 10 minutes, is that right?
Yes, Your Honor, thank you very much. Good morning, everyone, counsel, may it please the court, Julie Myers.
And can we start with the point that we were just discussing with Ms. Olson? And I mean, this isn't the first case where the state, whether it's the city or Hamilton County, has not opposed an expungement, and the court rejects that, and then you all are coming up in appeal and trying to defend a state interest that you never articulated. Like, I don't know what we're supposed to do with that. Like, if it's a concern to you at the trial court level, then it seems to me you have an obligation to raise that to the court and to then be able to have a debate let the other side understand what your interest is to be able to respond to that. And the way that this has shaken out, and not only in this case, but there have been a couple of others in recent memory where this has happened, like it kind of, like, I don't know what we're supposed to do with that. So can you, I don't know, that's kind of a rambling question, but can you help us out there?
Yes, Your Honor, I do appreciate the question. I would direct the court's attention to the case that defense counsel has cited, State v. GH. I do believe that this court specifically has addressed this very specific issue, a question that you've presented to me today. That case, the holding, the court did address that where the government has not articulated any need to maintain the offenses to justify a determination that the government's issues outweigh the interests, that it would be an abuse of discretion alone for the court to rely solely on the nature and the number of offenses. So the state does not have to make an argument specifically for the court to have an opinion. If the state does not address an objection on the record, it is still within the trial court's discretion to make a ruling. And that's exactly what the trial
what I'm
court
asking is, how is that ultimately fair to the applicant? Because normally the way the adversary system works is you all object and say, this is why we're objecting. She gets to hear that and then gets to make a counter argument. If you all don't object, and the first time she hears this is when the trial court issues its decision, like, she never gets a chance to address that argument.
I do believe that the court is in the best position to have all of the information about this applicant. And that puts the court in a position to make a sound reason and judgment despite an objection or a non-objection from the court. And the trial court did allow the applicant to state her position for why this should be granted. And the reasons that the applicant gave are very, very vague.
Right, but this is exactly where I'm going, is they were vague, but if you all came and said, we have a problem with that, Judge, like, it's way too vague, like, this is just like anyone could come in and say that, then, like, I don't know what she would have done. She didn't have a lawyer, but, like, maybe she would have elaborated further and provided more context to, I mean, this is the issue.
Yes, and I do believe that the trial court did give her an opportunity to provide more information. And I understand Your Honor has additional questions on why the state didn't object and why we are objecting now. But the standard is abuse of discretion. Did the trial court abuse their discretion in granting and denying this application? And the answer is no, they did not abuse their discretion. This case is distinct from State v. GH, and I think it's very important for the court to note the distinctions. In that case, the applicant was seeking to have a violation of a protection order expunged. They brought forth evidence at that hearing that the applicant lost his teaching job and had to retire early due to the convictions, that he was prevented from obtaining a work visa in a foreign country, and in that case, the applicant committed no offenses since the 2017 BPO offense that he was seeking to have expunged. The court denied the application because of the serious nature of the BPO. That is not the case that we have before you today. The case before you today, in the city matter specifically, I'll let my co-counsel address the county matters, they did not deny the application because of the seriousness of the underlying offense. Rather, they were denied because there was no evidence to support that she was rehabilitated. She stated general statements, but it was that it's just not me. It's just not me anymore. That's not enough.
But we do have the evidence of the CQE, and we do have evidence of a significant time gap between any convictions. And if that's not the case, like, again, it was on you all to identify why that's wrong. So, like, why isn't that enough to show rehabilitation?
Well, I think it comes down to the distinction in the cases. I think the trial court is correct, and that did not show that she's rehabilitated. And I know Your Honor had asked a question earlier about the convictions that happened after the charges that she is seeking to have expunged. And that is noted in the court's order, Your Honor, so that is reflected. Since the 2012 conviction, which is the earliest of the two for the city cases that she's seeking to have sealed, there was charges for unauthorized use of property, resisting arrest, obstruction of official business, theft, leaving the scene of an accident, and then there was at least 2 other cases from out-of-county jurisdictions that I believe defense counsel has noted.
But that's where I get confused on this, and you can help me, because, we have a situation where our legislature has said unlimited misdemeanors, understanding that people are going to have a situation in their lives where they've accumulated a bunch of misdemeanors, and then whatever, they if it was because of addiction issues, they clean up. If it was mental health, they get things straight, they clean up, they grow up, and then they stop. And then they start living a law-abiding life. So don't you look at rehabilitation at that point, and you've got all your misdemeanors back here, and you just kind of, you start your rehabilitation assessment from the last misdemeanor. Isn't that the way you should look at it?
I believe that's one way to look at it, but I think it's important to look at the entire picture. And the charges that she is seeking to get sealed, she has committed ones after that has happened as well. And she is not showing that she is changing her lifestyle.
How could you ever do that, though? If you have a bunch of misdemeanors and then you start living your law-abiding life, like, how long do you have to wait to show rehabilitation at that point?
I don't think it's a time that we have, a specific time frame that we have to look at. I think we have to look at time as a factor, but I don't think that's the only thing to look at. That is a piece of the puzzle. And the rest of this puzzle for Ms. Newsome is whether the trial court was satisfied to her rehabilitation.
Counsel, it sounds to me like the trial court is never going to be satisfied in this particular applicant's circumstance, because what he appeared to be concerned about was a potential employer's ability to know about the conviction. There's language in the trial court's order, and I'm paraphrasing a little bit, about employers being able to decide for themselves whether they wanted to hire her or not, given her background. How would you respond to that apparent concern that the trial court has about employers knowing about her record when making an employment decision?
I absolutely think that is something that the trial court is allowed to do. I don't think that's abuse of discretion. I do think that there would have been additional information that could have been provided to the trial court to help show that she's been rehabilitated, but she hasn't done that. She could have brought in documentation, to show what else she has done. I understand the QGE that she's been referencing, but that is to help her get employment. She already has employment. Now she says that she wants to advance her employment, but she's brought no documentation to show that her actual criminal history has prevented her from advancing in her career.
But I guess, like, that's almost a circular argument, because if you have reason to believe that your criminal history will prevent you, which I think is a reasonable belief for most people, like, why would you go apply for a job that you want knowing that you're going to get rejected, or believing that you're going to get rejected? Why wouldn't you try to get this cleaned up first before you apply for it? Like, you're not saying that you have to go show I got rejected from employment, are you?
I think that would definitely help. That is something that she should have looked into to see, is this actually going to prevent me? There were other charges that...
Would that go to rehabilitation, or would that go to her need for the relief?
I believe that would go to her need for relief, Your Honor, but I know that I'm out of time to quickly wrap up the question. Thank you. I believe that would go to her need, but I would submit on the fact that I don't believe that she has shown a true need to have this be sealed from her record, and that when you take in all of the facts that we have in the record and what the court has specifically addressed and the distinctions between this current case and the case cited, State v. GH, I think the court will see that we are having a different result because we have a completely different set of facts. And
counsel, I have one additional question for you. Is there any res judicata or preclusive effect of the CQE order?
I don't believe so, Your Honor. I believe, in this situation, I believe the trial court is able to address this and make the determination, and I do not believe that there was a abuse of discretion.
Great, thank you.
Submit for co-counsel. Thank you.
Mr. Hill, good morning.
Good morning, Your Honor. How are you?
I'm great.
Did I get my 5 minutes? Or?
You have 5 minutes.
Okay. I think the important thing to remember here, Your Honors, is that we're ultimately talking about a situation where the defense, or the applicant in this case, is asking the court to second guess what are ultimately a number of subjective determinations. And the standard of review here, moreover, is an abuse of discretion. Just because a defendant is statutorily eligible for expungement doesn't mean that they're automatically entitled to it. The statute is clear that the judge has to weigh a number of factors and then determine.
So let me ask you the same question I asked Ms. Myers, which is, like, if you guys care so strongly about this, that you're defending this appeal, but you don't stand up in front of the judge and say, Judge, we object, and here's why. Like, I guess I'm having trouble reconciling that.
Judge, the state's interest, the Hamilton County prosecutor's interest in this case, is more a function of what the defense is ultimately asking the court to do here than anything pertaining specifically to Ms. Bryant. I mean, it's true that we did not object, at the trial court level to the expungement of her, or sealing of her record. But what we feel the defense is ultimately asking the court to do is to basically say that under any circumstance where we don't object, trial courts cannot make their own determination that granting an application is not appropriate. We're trying to defend here.
I don't think they're arguing that, though.
What's that?
I don't think they're arguing that.
That was my takeaway, Your Honor.
I feel like maybe
everything.
What I understand is that they're arguing is that the judge based his decision on improper reasons. I mean, the rehabilitation, for example, was based on her multiple offenses.
Well, I would disagree with that assessment, Your Honor. I mean, the judge based his determination that there was a lack of rehabilitation not only on the nature or number of convictions, but also the fact that subsequent to the offenses which she was applying to have sealed, that she committed additional crimes. Now, I know there was some discussion when Ms. Myers was up here relative to what's the appropriate time frame. The statute is silent on that. It's ultimately the judge's determination whether or not a defendant has been adequately rehabilitated.
So let me ask you, from the state's perspective, is 4 years enough?
I mean, ultimately, Judge, the issue here isn't what we think. It's a subjective determination. We're talking about a situation where reasonable minds could disagree. I mean, personally, if it were me, I would probably have not objected to Ms. Bryant's. But someone could reasonably say that given that she had a 7+ year history from 2012 when she committed her first local offense up to 2019 or 20, whatever it was, 7+ years of committing criminal history, that 4 years wasn't enough to...
This seems to fly in the face of legislative intent. I mean, we have seen the expungement laws in Ohio become more and more generous.
Sure.
And now we have unlimited misdemeanors that you can expunge, right?
Sure, but just because your eligibility is the threshold issue, just because an applicant is eligible doesn't mean that, they're necessarily appropriate.
I agree with that.
Right.
I totally agree with that, but isn't this judge basically ruling that the number of misdemeanors is what is showing that she's not rehabilitated?
Well, not just the number of misdemeanors, it's the continuation of criminal conduct. And you have subsequent misdemeanors after the offense is at issue, and ultimately it's the judge's place to make the determination of what constitutes rehabilitation.
Well, maybe I'm not understanding. I thought she was trying to expunge all of her misdemeanors.
Well, so she's got some out-of-county things, I can't speak to it. And that's what I'm specifically referencing, is that after all of the things that she applied to have sealed here, she committed out-of-county offenses.
Did she commit any crimes after 2019, though?
Not that I'm aware of.
Okay, right.
Not that was borne out by the record.
So she stopped committing crimes in 2019 and got her life together, basically.
That is one way of looking at it, and that's ultimately the trial court's place to make the determination. But I think there's also a second issue here, which has to do with the balancing of interests. And I know there's been discussion about what Ms. Bryant's employment interests are. There was discussion of whether her record had been prohibitive in the past or not. The record is a little ambiguous on whether or not it had actually prohibited her from getting previous employment, or if it would in the future. But the court identified what I believe is, in fact, a pretty compelling interest. We've got an applicant here who's going to be put in a position of really serious trust with vulnerable populations, and the trial court recognizing, hey, an employer or some such for this line of social work might want to know that this person has victimized people in the past. I think that's a totally appropriate consideration to make. So we've got two grounds here where the court has indicated that it doesn't believe granting is inappropriate, and I think both of them are borne out by the record before it. It's not arbitrary, it's not unreasonable. Reasonable minds could perhaps disagree, but ultimately what we're talking about an abuse of discretion, and we don't believe that there was an abuse of discretion.
Counsel, can you address the impact of the CQE order? And this is something I'm struggling with. So in the CQE proceeding, the trial court made an explicit finding that Ms. Bryant established by a preponderance of the evidence that she had a substantial need for the CQE in order to live a law-abiding life. And then in the weighing process, the trial court is supposed to weigh her need against the government's legitimate interest, if it has any.
Correct.
Now, there's been a previous finding that she has a substantial need. So the government would need a substantial interest at the very least to have an equal weighing. How do you respond to that?
I have a number of issues with this addressing the CQE that was first raised in defendant's reply brief. Now, admittedly, I wasn't aware of it, so I did have to educate myself a little bit on the CQE. I'm not particularly familiar with it. I do know it's a different court, a different judge, a different legal standard. I believe there's basically a rebuttable presumption of rehabilitation after a certain statutory period of time. Our position on that is that it is not res judicata relative to any determination that Judge Berkowitz in this case had to make relative to whether she had been rehabilitated or what the needs were relative to one another. We wholeheartedly disagree with any contention to that effect.
All right, and you're past your time now. Yes,
sure I am. Thank you.
Thank you. Ms. Nelson, you have 3 minutes.
Thank you. Okay, just to correct a misstatement, I acknowledge the CQE discussion in my merit brief at page 12. So that was definitely before the court with enough time for the state to reply.
Sure.
It's before the court. It was before the trial court. And I am very intrigued by your questions about the res judicata application. It wasn't something that I necessarily considered, but I think that there's a point to that. Why is it when there's no criminal activity between 2021 when the application was granted and 2023 when she applied for record sealing, there's no change in circumstances? Then yes, I think that that finding should have some persuasive effect. Finding, I didn't brief that, but definitely persuasive. The statute is not necessarily silent as to timing. A person can apply for record sealing on a misdemeanor offense 1 year after completion of disposition. Ms. Bryant could have gone to those out-of-county courts and applied to seal the 2018 and 2019 convictions. Hypothetically, that court could have granted them, and then she could have come back to Hamilton County and we'd have a different conversation. We'd be looking back at 2017 in Hamilton County. I just say that to the court because it is arbitrary for the court to say, oh, well, from 2019 and then reversing back in history, she's had this spree of criminal activity. That is inconsistent with what the legislature says in that 1 year after 2019, she is eligible to have that case sealed, and we're dealing with no criminal history between then and 2023 when she applied. We are challenging the two factors that were cited by the trial court in this case. I'm sorry, to the extent that the interest balancing factor is what the court, I wanted to revert back to that because I think it is significant that the court isn't relying on an interest that is offered by the state of Ohio, the city of Cincinnati, to the extent that the case law allows the public interest to be a viable consideration for the court. In all the cases that were cited by the state, that was something that was articulated by the prosecution at the hearing, and we don't have that in this case. And when the statute contemplates the government's interest, I stand by that the language of the legislature requires that interest to come from the state, not from the judiciary. These are remedial laws. They should be liberally construed in favor of the applicants, and the state has provided no persuasive reason to uphold the trial court's decision, particularly in light of this court's decision in GH. If there are no further questions, I'd ask this court to reverse in order that her applications be granted.
Great.
Thank you.
Thank you. Thank you all for your arguments today. We'll take the case under submission and issue a timely written decision. Hope everybody has a great day.
All rise. Court of Appeals for Appellate District is now adjourned.